it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
You've reached the stars, now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
You've reached the stars, now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
You've reached the stars, now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem, let's grow wealth for you.
Good morning, everyone. Thank you for joining us today. Robert Kiyosaki said, "It's not how much money you make, but how much money you keep and how hard it works for you and how many generations you keep it for." And on this note, I would love to welcome you all to our webinar titled Inheritance Now and After. My name is Omowumi Adewale, and I will serve as your moderator for today. Estate planning is an important and everlasting gift you can give to your family. And setting up a smooth inheritance isn't a bad one, you might think. This is why this section today will be discussing and educating ourselves on different estate planning tools available to ensure that our accumulated wealth and assets is adequately transferred to the next generation. And on the other hand, how to access the assets of deceased loved ones through probate management. At the end of this session, we would certainly have gained the right perspective on various estate planning tools and how to assess the inheritance of our deceased loved ones. To help us dissect this interesting topic today, I have seasoned professionals on this subject matter. Please welcome with me, Mrs. Adekpeju Odusanya. Mrs. Adekpeju Odusanya is the Chief Magistrate Court of Lagos State Judiciary. She is an alumnus of Ogun State University, now called Olabisi Onabanjo University. She was called to bar in the year 1993. Presently, she's the head of department for the probate registry, Igboshere, Lagos State. She has been a magistrate since 2004 and sat in environmental court. She was the coroner for Ikeja district and have attended both international and local trainings on restorative justice, sentencing, arbitration, and mediation. She is married with children and loves traveling and reading. And here with me, I have my beautiful colleague, Foluo Olowofoyeku. Foluo Olowofoyeku is a trust officer at Meristem Trustees Limited. And I also have here with me, Feishayo Obatola. Feishayo Obatola is a probate officer at Meristem Registrars and Probate Services Limited. These beautiful individuals will be dissecting and addressing all our questions and providing solutions on estate planning as well as probate management. You're welcome, Foluhon and Feishayo.
Thank you.
Thank you very much. So, my beautiful audience, I would simply advise that you kindly drop in your questions and answer in the Q&A box. You can also reach us via mail, probateservice@meristemregistrars.com, or you can call our phone number on 080-977-96655. I'll take that again, 080-9779-6655. Thank you. So, to the business of the day, I'll give the floor to a seasoned professional, a barrister at law. Welcome with me, Foluhon Olowofoyeku. Thank you.
Thank you very much, Omawumi, and thank you for this opportunity to talk about this topic. So the topic of the webinar is titled Inheritance Now and After. And when we usually hear inheritance, the first thing that comes to mind is what we receive from our parents, our uncles, our aunties, our grandparents. However, it gets to a point where we begin to accumulate and build wealth that we also need to think about preserving this wealth and transferring it to the next generation. And that's what we mean by inheritance now. So it's the process of preparing for the inheritance you're going to leave for your generation, your loved ones, and beyond. So this can be done through a process called estate planning. Estate planning is simply the arrangement and organization of assets for the transfer to the next generation. And usually we think, okay, we can leave this off till a later date. But it's important to begin to plan your estate now. And this is important because unfortunately, life is unpredictable. And we need to ensure that the lifestyle of our loved ones remain the same even in our absence. Additionally, it also gives you control over how your assets are actually distributed. For example, you might want to give a portion of your assets to charity, but if this isn't documented anywhere, nobody is going to know that that is your desire. So it's important that you plan your estate. It also avoids crisis in the family or, unfortunately, disputes and fights and quarrels over your assets. So this is why it is important to plan your estate and ensure that you're leaving the inheritance you want for your loved ones and your beneficiaries. So how do you plan your estate? What are the tools available to actually plan your estate? One of the most common tools is a will. A will is simply a legal document that contains the wishes and directions of an individual regarding their assets. For example, I give my house in London to my son. I leave my house in Lagos. Obviously, you have to be more specific, but I'm just giving examples, to my daughter, and so on and so forth. Why is it important to have a will? Like I mentioned before, it gives you the opportunity to actually direct and give your wishes. It also allows you to appoint executors who are trusted individuals, or in some cases, corporate entities, to actually carry out your wishes. Also, if they are minors, you can actually appoint guardians for your minors in your will. Most people think, oh, I need a certain amount of money before I can actually prepare my will, or they say, oh, I don't own a house, I don't own a car, what do I need a will for? Well, there are different will services that we actually offer, and one of them includes a product called a simple will, which caters to simpler assets, and then we also have the comprehensive will, which caters to more, I won't say complicated assets, but more elaborate assets like landed property, jewelry, and cars and things like that. However, it's important to note that a will is subject to probate, and with probate comes estate tax. And this might cause some delay in the transfer of assets, which is why a living trust is also a viable tool that can be used. A living trust is a legal instrument, a legal arrangement whereby the assets of the person setting up the trust, who is called the settlor, are actually transferred to the trustee to hold and manage for beneficiaries during the lifetime of the settlor and beyond. The advantage of this is that because the assets are actually no longer in the legal ownership of the settlor, there is no need for the probate process. And because there's no probate, there's no estate tax. So this means that the transfer of assets is actually very seamless. And of course, it's a very confidential document. The living trust is an extremely confidential document. A will, after being read, it's a public document, but the living trust, the trust deed that is drafted, which is the document that contains basically the terms and conditions and how the assets should be transferred and managed, that document is extremely confidential, which means it's only between the settlor and the trustee. Even the beneficiaries might not have access to the document, so they might not know other beneficiaries. So it ensures strict confidentiality and, of course, smooth transfer. So you guarantee that the inheritance you're leaving for your loved ones is going to them. You're sure that nobody is going to come and take those assets. You're sure that the inheritance, your wealth, your legacy, it's transferred in the exact manner that you want. Another tool is the testamentary trust. Now, a testamentary trust is it's a will that sets up a trust. So it's almost like, it's basically a combination of the last two I mentioned, the will and the living trust. The difference is, in the will, as opposed to giving the assets directly to the beneficiaries, you actually give the assets to the trustee who hold and manage for the beneficiaries. So it's a will that sets up a trust. And of course, like a will, it goes through probate, it goes through estate tax. So you might wonder, well, why do I need this testamentary trust then if it has probate and estate tax? Well, one of the advantages is if there are minors involved. So if there are minors involved, then, and you might feel like the minors might not be able to manage the caliber of assets you're leaving for them. So this allows you know that the assets are not going to be wasted. They are going to be managed properly until those minors reach a certain age where you now trust. For example, in the document, you can write, when my child attains the age of 30, then the trustee can transfer all assets to them. At that age, you're confident that by then your child has matured to a certain level where they actually know how to handle those assets. Another very good advantage of a testamentary trust is that because those assets are not directly given to the beneficiary, any creditors of the beneficiaries, they don't have access to those assets. So a trust arrangement also has the advantage of shielding the trust assets from any creditors or any third parties that might want access to it, because the direction in the will says give to the trustee. So legally, the beneficiary technically doesn't own the asset. So any creditor trying to claim the asset does not have access to it. And it's the same for the living trust. Your creditors as the settlor and the creditors of the beneficiaries don't have access to those assets. The last tool I'll speak about is an education trust. And the name speaks for itself. It's an arrangement that caters to the educational needs of the beneficiaries of the trust. And this allows seamless and smooth continuity of the education of the beneficiaries, regardless of what happens to the settlor. So for example, you wouldn't want a case where your child is in a certain school and due to the unforeseen events of life, the child has to change school because they can't access your assets and there are all these issues around, and then maybe the child has to change school or come out of school for a certain period or something like that. But we have an education trust that is catering to the educational needs of this child. Regardless of what happens, the education of the child continues smoothly. So, like I said, just a brief recap. Planning your inheritance is important. While we all hope that we live long and fruitful lives, it is still important to ensure that we actually ensure that we put plans in place to ensure smooth transfer to our beneficiaries. Thank you.
Thank you very much, Folohan, for that beautiful presentation. That was quite amazing. I'm sure you're learning just the way I am as well. So now I'll be calling up Your Honor in person of Mrs. Adekpeju Odusonya, which is the Chief Magistrate with the Lagos State Judiciary, should please give to us from her wealth of knowledge. Your Honor, you're welcome.
Thank you, Wumi, and thank you so much for inviting me. And many thanks to the Honorable Chief Judge of Lagos State for giving me the opportunity to be here today. So we can go on. Hello, Wumi, are you still there? Hello?
Yes.
Hello, Wumi.
Yes.
Very well. I said earlier that I'm thanking your organization for this invitation. It is an opportunity for us to showcase what we do here at the Lagos Probate Registry. Ikeja Probate Registry also inclusive. I also want to point out that in Lagos, it's one probate registry. It's just for ease of administration that it's divided into two. And right now we are also having mini registries in some suburb areas so that it'll be easier for people accessing either grant of probate or letters of administration. In the course, before the end of the year, we want to open mini registries at Ikorodu, Ekpe, and Badagry. Now, back to the topic of the day. I think we need to explain some terms before going further. Terms like inheritance and what is probate itself. Inheritance is the devolution of properties on the beneficiaries upon the death of the owner. And probate itself is the process of proving and administering an estate. It is the analysis and transfer of administration of estate previously owned by a deceased person. Probate is a legal process that authenticates and validates someone's will. So when we are talking of probate, it can come in two ways. Either the person has a valid will, then what we get is a grant of probate. And where the person died intestate without a valid will or without a will at all, then a letter or letters of administration will be obtained. So either of the two ways, administrators or executors can legalize their administering the estate of a deceased person. It is an offense under the law to tamper with the estate of a deceased person without having the authority to do so. So we move on to how a grant of probate can be obtained, and also how you can obtain letters of administration. The first thing for for a grant of probate is that there must be an existing valid will. I said valid will in the sense that the will itself must be valid. Nothing must defeat it in the eye of the law. And what some things that can defeat a will, that can make it void, are many. One of it is that a will that is not signed in law, the law does not recognize that, is void. If the testator, that's the writer of the will, in law, the person is regarded as the testator. If the testator did not execute the will, valid execution, it has to be valid, not just any execution. There must be valid execution of the will. So if the testator did not execute the will, it is void. Then it must be witnessed. You don't just sign. The will the testator must sign in the presence of two witnesses who must also sign one after the other. So the three of them must be must sign at the same time. So in Lagos State probate, the will has to be lodged. And if peradventure it wasn't lodged before the death of the testator, it can be lodged thereafter. And that's how we have a detached will. A detached will has to be lodged with the consent of the family members, who will depose to affidavits that, yes, it's true. Our father made a will while he was alive, but he was not able to lodge it. So after the will has been formally lodged at the probate registry, the beneficiaries or the executors or their legal representative can write the probate registry to get a date for the opening and the reading of the will. I said opening and reading because on the day fixed for the reading, the will be shown to the family member present. It has to be sealed, and it will be open in the presence of everyone who will sign that, oh, the will was open right before us. So the will be read, and we usually advise them to apply for certified true copies of the will. 3 copies must be in the court's file. Thereafter, they can now apply for grant of probate. So who are those that can apply for grant of probate? The executors can apply. They are the one charged with the duty of applying for grant of probate. One of the advantages of making a will is that the testator has the power to appoint whomever he likes as the executors. The work of the executors are many. They are the one charged with bringing to pass which is an intention of the testator, which has been reduced into writing. We can also have situations where the executors, for one reason or the other, might not be able to take out probate. It can be that they even predecease the testator. It can be by reason of old age, and that they can no more have the physical ability to do it. Some might even say, oh, I've retired in Lagos and I've moved to my village. Coming to Lagos from my village is a big task for me. And some might even renounce that, oh, for reason best known to them, I'm renouncing probate. So I usually I have the opportunity. I usually advise whenever you want to make anyone an executor, tell them before you putting their name in the will. We have had situations where people will come, oh, I was never informed, I was charged with such duty, I'm not willing to do it. So it's advisable to testators, whenever you are appointing anyone as executors, let them know. So the executors can apply, and wherein the executors are not willing to do the job, the option left for the beneficiary is to approach the court. So the court will appoint administrators with will annexed. So the administrators will still do the will, and which is carry out the intention of the testator. Like I said earlier on, that probate is the judicial confirmation of the authority of the executors, executor or executors, to carry out the provisions of a will. It is usually granted upon an application made to the probate registry by an interested person, either personally or through their legal representative. The law says that we cannot grant probate 14 days after the death of the testator. So no probates can be granted 14 days. It has to be after. So once the application is made, for the executors seeking to apply, the will, there must not be any caveats on the will after it has been read. If there is a caveat, the registry will seek action until the caveat is withdrawn, or if there is a case pending in court, we have to wait for the outcome of the case in order not to preempt the decision of the court. So now I want to talk about the situation where there is no caveat and there is no case pending in court. So once we have the application, we need, before the will is, at the reading of the will, we need the receipt of lodgement. We also need receipt of lodgement. In situation where the beneficiary cannot bring forth the receipt of lodgement, maybe it's, they can't just find it at home, or for reason of misplacement, we advise them to go to the police with an affidavit, and the police will give them the papers to come forth with. We act on that too. So after the reading of the will, the application will be brought to the court, to the registry rather, and then a set of forms will be given to them. We need means of identification of the executors. We need 4 passport photographs for each. The law also says that a minimum of 2 executors can apply for probate, a maximum of 4 at any time. It's possible the testator may have appointed more than 4. And it's also possible that out of those appointed, all of them might not be, 1 or 2 of them might not be willing to take out probate. So we go in the hierarchy in which the name is listed in the will. Wumi, are you still with me?
Yes, please.
Okay.
Yes, Your Honor.
Yes, I just want to be sure that we are still together. Yes. I said for the executor making an application for probate, we need their means of identification. We also need their passport photographs. We also need passport photographs of the deceased testator too. We ask for that. Then we give them set of forms. Included in this set of forms is the bank certificates. The bank certificates will be taken to various financial institutions wherein the credits the money standing to the credit of the testator will be endorsed on the bank certificates. In some situations, the applicant might say that, oh, we are not ready to do real estate. We just, when I say real estate, buildings, immovable properties that for now we just want to do the money in the bank, they are allowed. We at the registry, we don't determine to what extent applicants want the probate to be granted to them. It depends on them. Some will do the two together, both real and personal property. Some will say, oh no, just for now we want some money in the bank, and we'll come back for additional assets when we are ready for others. So once the forms are given to them, the bank certificates, inventory forms, executors form, oaths forms for the executors. I'm limiting myself for now for the grant of probate. I'll still go to the letters of administration. They will return the forms fully filled. Once the forms are filled, then we take out assessments. It will be assessed. At this stage, it will depend if real properties are included. The file will be sent to the valuation department. But if there is no real property, we do the assessment here. And one thing is, once the forms are returned, if there are no real properties, you can get the assessment sheets within 48 hours. So we are doing all we can do to improve our services here and to erase the notion. Some people do have the notions that, oh, it's very, very difficult to get a grant of probate or letters of administration. We are doing all we can here. So we can get the assessment done after the forms have been returned within 48 hours if there are no real properties on the estate. But if real properties are involved, the valuation units too, they have to do their job. Sometimes, if it's not a prototype type of properties, they will need to do physical visitations so as to assess the value. Assessing the value depends on the type of property involved and the location of the property. Then it also depends on the shape, as in if it's a property that's it's not in good shape, that can also goes into what determines the assessment to be given, the valuation to be given. So once they have done their job, they return the file back to the registry. We'll do the assessments, and then once the estate duty have been paid, the file is sent. If there are real property, the files is sent to the probate judge, who will sign. Then the files also go to CJ, the chief judge, the honorable chief judge, once there are properties involved. So the file returns back to us, and we do the marking of the will. This is where the executors are physically present with the witnesses. In situation where the witnesses could not be located, it's possible, since most beneficiary does not even know when the testator made the will. They can say that, oh, we know the testator was our father's friend, but right now he has moved to the village. We don't know his phone number. In such a situation, we tell them to depose to affidavit concerning that. Then the executors are interviewed, and then they sign, they mark the will. For grant of probate, there is no need for publication, since the testator has already determined who is going to be these executors. So there's no need for publication. For LA, there is every need for publication, which is 21 days. So we can, from that one, the grant of probate will be prepared. Then it will be sent to the probate registrar for final assent. That's that in a nutshell. And if by adventure not all the properties of the deceased was captured at in the grant of probate, they can always come back for additional assets. And wherein there is a caveat on the file, it's possible there might be disgruntled elements among the beneficiaries. That will also determine how long the application stays in the registry, since we are not able to do anything once there is a caveat on the file. Yes, Mumi, can I move on to LA?
Yes, please, you can.
Very well.
Thank you, Your Honor.
For letters of administration, that presupposes the fact that there's no will. So the family, in most cases, in accordance with the dictates of the law, they are the ones that will determine who will represent them. The law says not everyone can come forward to apply for LA of a deceased estate. The law states the hierarchy of those that can apply for LA in respect of a deceased estate. And I will also be quick to mention this, that immediately if a man dies intestate without a will, the property of the deceased for the meantime is vested in the chief judge of that state wherein the deceased resided before his death. There might be a situation where if anybody now goes to tamper with the estate, it can be he or she can be charged under the law for a criminal offense. Nobody is allowed to do that. The law made provisions to accommodate this by laying down the procedure for the grant of letters of administration. It must be noted that LA is granted upon application by those that are entitled, either personally or through their legal practitioner, to the probate registrar. The application will have to be submitted to the probate registrar. Those that can apply for LA, as the law recognizes them, are the spouse of the deceased person, the children of the deceased person, the parents of the deceased person, blood siblings of the deceased person, the grandparents of the deceased person, half brothers and sisters of the deceased person. In that hierarchy. So not everyone, a friend cannot just come up, oh, I'm the friend of the deceased, I want to apply for LA. We will not oblige that. So at the initial stage of application, we usually ask them, what is your relationship with the deceased person? And you must be able to establish that. If we are not sure, the law allows us to ask for more evidence. We have seen situations where those that are not really even like cousins, nephews, because they are bearing the same name with the deceased person, will come forward with application that, oh, he's my father. It's in the process of we asking further question, asking to be further convinced that they will stop coming. The rightful people will come up later. We have seen situations that the wife maybe and the children are in the village, and the cousin will come up, and the brothers and sisters who are in Lagos, because the wife might even be an illiterate who doesn't know what LA is all about. So it's in the process of we asking questions to be further convinced that it's the rightful people that are asking or that are applying that we discover. Then we now ask them, reach out to the wife. We want to speak to the wife. We want the wife to come to the registry. So at times when that is discovered, we ask them, put the name of the spouse, put the name of the children. So once we are sure of the standing of those that are applying, then they will be given a set of forms. Included in this set of forms too is a bank certificate, which they have to take to the financial institutions, who will endorse on it, credit standing, money standing to the credit of the deceased person. The law says that a letter of administration cannot be granted until after 21 days of the death of the deceased person. No letters of administration can be granted until after 21 days. Just like I said that there's an order of priority for those that can apply. Before initiating the process, it is also necessary to know and have all the required documents that will be needed. We have the application letter to the probate registry, and this must contain full names and address of the deceased person, the date of death. We need a copy of the death certificates. The original will be returned. If the person did not die in a government-approved, medical center or general hospital, or we'll tell them that they should take the report of the death certificates, the medical report of death issued by a private hospital. They should take it to the nearest local government where the deceased resided. The MPC, the National Population Commission, officials there will issue a death certificate. Then full names and addresses of the proposed administrators. The application letter will also be accompanied by the passport photographs of the deceased person, passport photographs of all the proposed administrators, means of identification of all the administrators, their phone numbers, and close relation to the deceased, which may either be, like I have explained, father, mother, sister, children. And in the filing and submission of the following forms, together with the payment of invoice, there will be, we have the application for a grant of administration. Those are the forms that accompany the bank certificates that will be given, set of forms that will be given to them after the application fees have been paid. We have the oath for administration without will. We have the administration bond. We have the inventories. We have the particulars of freeholds, properties that they want to probate, declaration as to next of kin, and schedules of debts due by the deceased person. So they have to, the bank certificate will be given to you, and you have to pay for the forms fee. We gather all the assets of the deceased, both movable and immovable. You get the balance standing to the credit of the deceased stamped on the bank certificate. Then all the required estate fees as assessed, if like it happens for the grant of probate too, where there are no real properties. It's the file will not go to the valuation units. But if there are real properties on the estate, the file will go to the valuation units. They will do the evaluation. The file will be returned back to us. We will do the assessment, which will include the evaluation, the assessment evaluation I've done on the real properties. The file, the assessment sheets will now be given to the applicants. If they pay at this junction, take the file to the probate judge, who will approve, and the file will also be approved by the chief judge. But at this junction, some might just decide that, oh, we want the real properties exempted because the applicant doesn't have funds to finance the estate fees that has been assessed. So if they want the real properties exempted, we remove it. If they don't, they might ask us that acting on Section 7 of the Administration of Estate Laws, which allows the CJ to administer the property of the deceased person with before the LA is obtained, we can write the banks wherein the deceased has funds and tell them that there is an application on the estate of the deceased person, and we know that the deceased has money in this particular bank. You are therefore to issue check in favor of the probate registrar, and the usual, most banks usually oblige us, so that the applicants will not be confounded with how they are going to pay the estate fees once the deceased has the sum that can cover it in the bank. So after the estate fees have been paid, there is need for publication if it's letter of admission, and it has to be publicized for 21 good days. After the end of the 21 days, sureties, they will bring forth their sureties who will be interviewed. And after that, the file will be sent back to the probate judge for minutes and orders. And if you come back to us at the registry, we draw up the order and we send it to the probate registrar who will assent to it. That's the final. That's the process in a nutshell.
Thank you so much, Your Honor, for the insightful presentation. And we would love to apologize to our audience. Your Honor is unable to open up our video due to the sensitivity of our role. We genuinely apologize for this. Thank you once again, Your Honor. Now we'll move on to the panelist session. And I have here with me my colleagues, Feishayo and Foluhon, who will be dissecting the Q&A alongside with Her Honor. Permit me to start with Her Honor because we have some questions in the Q&A box. Please, if you have further questions, kindly drop them in the Q&A box so we can read it out to the individuals involved. So, Your Honor, a question was dropped in the Q&A box and it says, what is the purpose of the passport photos of the deceased person? Please, why doesn't probate registry require these photos to be submitted when the will is being lodged? And why is it asked after the testator is dead?
Okay. Should I just go ahead?
Yes, please.
Very well. You know, people can be very funny, and I'm being down to earth now. It's possible for those, for a person that is still living, that they will come forward that they want to do, maybe the person is not in the country and they know he has property. They will want to come forward to say, oh, we want to do the healing of our uncle, of our dad, even while the person is still alive, to know that we are on the same page, and that if the next 10 years they should any issue should come up, we'll be able to defend our stand, just to make sure that is actually someone that is dead, that the papers for LA are being processed. See, you can't you don't really know the extent people can go through when it comes to acquisition of the properties of the dead. So we want to make sure that it's the same person that you are bringing forth. It's dead. We don't know the person. You are bringing forth the passport photograph. It will be in the file. Peradventure, something should come up tomorrow. Then we have something to rely on. And don't forget that, secondly, for letters of administration, there is no will. There's no will. So we don't have the particulars of the person in our custody, unlike where there is a will. Before lodgement of a will, we need passport photographs of the testator. We need their means of identification. We need their phone number. See, people do come up with a lot of issues. There have been an old man that have been here that is, he wanted to lodge his will. When we went through our platform, we found out that a will has previously been lodged in that name.
Wow. Wow.
And the man said, no, I don't know anything about it. So we need to be very sure. Even at the point of, the law says that even if it's at the point of handling the papers to them, we can still ask questions. if we are not convinced that it's the right person or persons that are processing the letters of administration. You know, for probate for grant of probate is a bit easier because the testator will have streamlined those that should do what and what. And if peradventure it's not going to be in line with the directives of the testator, there must be a reason. If the executors are not going to be the one to apply for probate, there must be a reason. And then for grant of probate, it's even only the executors. It's only if the executors, for one reason or the other, are not available that administrator will be appointed and they have to go to court. It's not something we just do at the probate. Okay, let me quickly point this out, that the probate registry is an extension of the family court and probate, family and probate courts. So the letter given out is actually given out by the LA given out is actually given out by the courts. The grant of probate is actually given out by the courts. No grant of probate or letters of administration can come out without minute and order. The minute and order is an order of the court. It's based on that minutes and order that we at the registry draw up the letters of administration and grant of probate. So we have to do all due diligence.
Thank you so much, Your Honor. Now I'll go to Feyi-Shayo. Now, we have a deceased individual and his beneficiaries have come up with facts and figures that he has shares in different registrars, which is actually listed in the letters of administration. Feyi-Shayo, how do we go about this to enable the beneficiaries have access to the shares?
Thank you, Omowumi, for this question. First, I would like to express my condolence to the attendee asking this question. It's never an easy thing to lose a loved one. So the process that refers or would deal with the question that is being asked is called the share transmission process. So in a case where a deceased person has shares in various companies and the administrators have been able to gather those assets and list them on the letters of administration, the administrators would be taking the next step, which is the share transmission process. This simply means gaining access to the shareholdings of the deceased person and the accrued dividends on those shareholdings.
Okay.
You know, so it includes submission of documents at registrars that have been identified, processing and ensuring that there is a conversion into an estate account managed by the administrators, and payments of outstanding and subsequent dividends into the estate accounts. It's also one of the services that Meristem Registrars and Probate Services Limited offer. So we can take you through that process as soon as the attendee is ready to move forward.
Thank you very much, Feyi-Shayo. Now to follow on, I have a question here in the Q&A which says, can beneficiaries be appointed as executors of the will?
Thank you very much. And that is actually a very good question. Yes, beneficiaries can be executors, but beneficiaries cannot be witnesses. It's important to note that the people witnessing your will, and I know this is not the main question, but this is also an offshoot of that question. So yes, while the beneficiaries can be the executors, the beneficiaries cannot be the witnesses of the will. Thank you.
Thank you so much, Foluhon. Your Honor, I have another beautiful question for you here, which says, are pension funds taxable?
No, they are not. By the Section Pension Funds Act, they are not taxable, because it is believed that these are savings of a worker all his life, and it has been taxed while he was working. So it cannot be taxed again.
Thank you, Your Honor. So, Feyi-Shayo, when we have individuals that intend doing, going through the probate services, how do they engage Meristem? How do they tell us that, oh yes, we have a deceased person, what are the things that are required for them to engage Meristem?
Thank you, Omowumi. Engaging Meristem Probate Management Service is as easy as putting a call through to us or sending us an email. So you can reach us at via any of our communication channels. We would speak to the client, set up either a virtual meeting or a physical meeting, review documentations that you have, put you through on getting those that you will need to get from other institutions. And as soon as we have all this together, then we'll be able to communicate the onboarding documents we will need the client to execute and set the ball rolling for the task. So it's as easy as a phone call or an email.
Thank you so much for that response. Your Honor, I have another beautiful question for you. And the questions goes thus. Before I talk about this question, it has always been a challenge in accessing the inheritance, the assets of deceased individuals. And that is what has actually birthed this question, which comes up from the Q&A. It says, is what can be done to make the probate process quicker and more efficient? It is currently very, very long-winded and tedious process and quite traumatic for the family. Please, how can this be done in a quicker and easier way? Thank you, Your Honor.
Okay, Umi, I will say in all this, it depends on the readiness of the applicants. Like I said during our discussion yesterday, we did in July, I signed one which took only 3 months. Only 3 months, because the applicants are ready. See, we are doing our bits here from our hand, and I believe we can also improve, and we are working towards that, improving every day. Some of these people that they will go out to say that, oh, it took ages, it took months. See, now when you bring your application fees paid, you get your forms and the bank certificate the same day. And I can tell you, if there are no real properties, no immovable properties in the file, you can get your assessment 48 hours after submitting the bank certificates. Once these assessments have been paid, the receipt confirmed, the whole process does not take ages. Now there is even the e-probate have been introduced since 2019. That means you can start the whole process from the comforts of your house. Then we continue when we get to the probate registry. Okay, do I go along and give them the website of the probate registry?
Yes, please.
Okay.
You can, Your Honor.
You can log on www.probate.lagosjudiciary.gov.ng. www.probate.lagosjudiciary.gov.ng.
Thank you so much, Your Honor. And the last question for you, Your Honor. Can a minor be on the letters of administration, knowing fully well that the deceased is the father, the mother is also late, and she is an orphan? That's the mother, which is the wife of the deceased, is an orphan. Now, the children are below 18. Who else can apply for the letters of administration? Can the minors apply?
No, the minors, they will have someone who will be their guardian, like their uncle, aunties. But the thing will be, it will be on the LA that they are applying. There's a form, the guardian ad litem form, to be included in the set of form that will be in the file and to be filled by the applicant who will be the guardian of the children. And it will be stated on the LA that the minor, upon attaining legal age, can take over the estate of their father. And that is when it's very necessary for us to ask questions. There was a particular scenario that came up sometimes last year. I found out from the next of kin form that the children are, I think, 17, and the second was 15 years of age. And I found out that the uncle and his wife had the applicant. I said, no, I need to see the applicant. And I invited the children. We go extra mile here, and we know where we are doing that for the future of those minors, so that the estate will not go into the wrong hand. So at the end of the day, I advised them, I said they have to wait until December when the first one will be of age, so that he will be included along with his uncle as the two applicants, so that whatever is happening on the father's estate, he will be abreast, he will be aware.
Know as well.
Yes, it's to protect them. The law says we can do that.
Okay. Okay. Thank you so much, Your Honor. My last question for Foluhan is, can an individual have both a will and a trust, as well as what happens if the beneficiary, you're keeping those things for, is predeceased before even the settlor? What happens, please?
Thank you very much, Wumi. These questions are actually
really tricky.
Yeah, and they're insightful questions, useful questions. So to the first half of your question, can an individual have both a will and a trust? The answer is yes. We, the professionals, will work with the individual to ensure that we cater to their specific needs and ensure that the assets they want to go in the will and in the trust are clearly understood and will be drafted accordingly. So short answer, yes, you can have both a will and a trust. For example, you could put your real estate in the will, and then you could put your cash and near cash assets in the trust. And one advantage of this actually is so that, because I remember Your Honor mentioned sometimes difficulty with the beneficiaries being able to pay the estate tax. So if the cash and near cash assets are actually in the trust, then they will be available to pay the estate tax for the assets that are in the will. Okay. So depending on the needs of the individual and how they actually want their assets to be distributed, yes, an individual can have both a will and a living trust arrangement. And I think the second half of the question, what happens if the beneficiary actually dies before the person that drafted the will?
We don't pray for that.
Yeah, of course we don't pay for that, but it's an important question. And with experience, we actually usually and will always cater for this in the document. So for example, there's usually a clause that says, and if this beneficiary predeceases me, the testator, then the assets can be distributed maybe to charity or to other beneficiaries, or in some cases can say, and if they have any children, then the assets can actually go to their children.
That's a good one.
Yeah, so it just, once again, the needs of the testator or the settlor, whoever is setting up the, whoever is planning their estate, their needs will be considered and what they want. So thank you very much.
Thank you, Folua. Over to Feishayo. So Feishayo, inheritance now and after. What are these inheritance? What are the assets that actually makes up the inheritance for transmission regarding probate?
Thank you, Mo. So assets covered, we're referring to probate or inheritance that we are referring to in this instance, could be anything. Could
like
monies in bank.
Okay.
Could be cars.
Wow.
Could be shareholdings. You have shares in companies.
Okay.
It could be intellectual property. Could be landed property. It could be probably some rights that you have. Some
copyright or intellectual
property, patent. It could be anything. So if it's something you can own, then it's something that can go through probate.
Oh, fantastic. So to wrap this up, So to wrap this up, I would be asking Faye Shayo one more time. How do Meristem come into play in all these things?
Thank you, Mommy. So I feel this is the most important part of this session. So if we have any of the attendees, or if you know someone, a close one, who has lost a family member and is looking to gather those assets together and be able to assess them for the benefits of those they have left behind, Meristem is a one-stop shop for this service. We offer probate service. We assist in gathering assets. We assist in the procurement of letters of administration. If you've also procured letters of administration and you have some shareholdings listed on them at various registrars, we can take you through that process, help you with submission of documents at those places, the conversion into estate account, getting access to outstanding dividends. We can do that for you. And if you already have an initial letters of administration or grant of probate and some assets are left out, we also assist with the procurement of a certificate of additional assets for the initial grant.
Oh, but if there's probably a misspelling in the letters of administration,
so what happens is also a service we render. We also assist with amendment of letters of administration or grant of probate. That will fall under the amendment process. So this would help you make corrections to names. If there are other names of the disease that were not taken note of in the initial grant to be included, if there are errors that need to be corrected, the amendment of letters of administration or grant of probate will take care of that. So Meristem is a one-stop shop for all your probate needs, and you can just reach out to us. We would have a meeting, you share your needs with us, and we would advise accordingly.
Meristem also helps with the drafting of your will, Meristem trustee. So while Meristem probate helps you with the after part, Meristem trustees is here to help you with the now part, with the drafting of the will, setting up the living trust.
So would you permit me to say you are inheritance now? And she seems to be the inheritance after.
You can say that.
All right. Thank you so much to our seasoned professionals. Thank you very much to Her Honor. We are super grateful for honoring our invitation and for the beautiful presentation as well. At this point, I'll be inviting someone I hold in so much high esteem in the person of the registrar, which doubles up as the CEO of Meristem Registrars and Probate Services Limited, to please give us the closing remark in person of Oluseyi Owoturo.
Thank you very much, Omomi. Firstly, I would like to thank Her Honor, Mrs. Adepeju Odusoya, for such a wonderful session, an insightful session. Thank you so much, ma.
Thank you for the invite.
Very grateful. Thank you. And my colleagues, Foluhon, Omomi, and Faye, thank you for an insightful session. To all our attendees, if you weren't here, we would have just been speaking to ourselves. Thank you for attending. I think this session is just the beginning of the conversation, and I'm hoping that we can take the conversation further. If you wish, the recordings will be posted on YouTube. So if you go search on YouTube, you'll be able to play back the recordings. And if you wish to have take this conversation further, if you go to the chat box, you would see our contact. So you'll be able to reach out to either Meristem Registrars and Probate Services or Meristem Trustees, or both of us, as the case may be, depending on your needs. We would also be sending you a link, the attendees a link to access the recordings for reference, for future reference. So thank you so much, and do have a beautiful day, the rest of your day. Thank you. God bless. Over to your mommy.
Thank you. Thank you, and thank you, everyone. Thank you for gracing this occasion. Thank you for registering. Thank you for your inquiries. And as our registrar has spoken, we'll be expecting more of your inquiries via our email address, which is probateservice meristemregistrars.com. You can also give us a call via 080-977-96655. I'll take that again, 080-977-96655. Thank you. And for our trustees number, it's already listed in the Q&A. Please send in your inquiries. Feel free to send us a mail. We would respond as soon as possible. Thank you, one. Thank you all. Do have a wonderful day, please.
Thank you.
Yes.
Were you listening at all?
Yeah, sure. It was
How did that perform?
very
Thank you. So what do you do?
I'm actually studying computer engineering in school.
Okay.
My 500 level.
Wow.
Yes, I'm doing my industrial training towards them.
Mm.
Yes, so that's basically what I'm doing right now. Yes, but I'm still having talks of having a second degree after school.
You've reached the stars. Now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem. Let's grow wealth for you.
You've reached the stars. Now let's see you conquer galaxies.
The beauty of wealth lies in growing, preserving, and transferring it. Building wealth isn't only what you do for yourself, it's what you do for generations to come. And to pull that off, you need partners. Partners who understand that the assignment isn't just to grow your wealth, but to preserve it against the harsh storms of life and ensure it sees the light of day, ready to be transferred from generation to generation. So you see, the art of building wealth is all about growth, preservation, and transfer. And at Meristem, we have perfected that art.
Meristem. Let's grow wealth for you.